Inside this Texas courtroom, tensions rise fast. A shoplifting suspect, a DWI defendant, and a trespass case all collide in one explosive morning. And the judge isn't holding back. Every excuse is challenged, every mistake exposed, and every defendant is pushed to face the truth. What happens next? You won't forget.
You ready? All right, let's roll, nerds.
All right, Judge, page 1, Aguilar, come on up.
You are Jose Aguilar Barrera. You speak English? Ok, tome asiento, por favor. Vamos a esperar.
All right, Judge, I can call the next one up.
Ok.
And then I'll text you. Page 11, Jackson, come on up.
You are LaToya Jackson. Ms. Jackson, you were charged with fraudulent destruction of a price tag. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to, bless you. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes,
Okay.
sir. On December 30th, 2024, the officer was dispatched to a theft at a business in Harris County, Texas. Upon arrival, the officer spoke with a loss prevention officer who advised he was watching surveillance when he noticed the defendant removing price tags off items and placing them on different items in her basket. The total was $136.27. And when the officer spoke with the defendant, she admitted to removing price tags and placing them on different items before checking out.
Jackson, I'm going to find that there's probable cause to go forward with your case. Do you have the ability to hire a lawyer, ma'am? Do you work? What do you do for a living?
Healthcare.
Okay. What kind of money do you make a month? Do you have any children? Okay. Do you get support for the child? Did you want to apply for an appointed lawyer? Okay. Do you mind giving an application, please? Deputy Lopez is going to give you an application. I'll have you fill it out. I'll see. I need to know everything about you, and I'll take a look to see whether you qualify. If you do, I'll provide your lawyer today, man. Please.
All right, Judge, I can call this better supervisor.
Okay.
There are any bond
Aguilar,
conditions
come on
for?
up.
Oh, I'm sorry. Thank you so much. Yes. No going, where was it from?
The Walmart?
Okay, no going to any Walmart.
Yes, Judge.
If you don't mind filing that, and then, hey, I forgot to do conditions, and so before she goes, we'll do, no going to Walmart.
That's from the state.
Yeah. All right, you are Aguilar Barrera.
Con palabra.
Sí, soy yo.
Yes.
Okay, sir, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer initiated a traffic stop after observing the defendant failed to maintain a single lane and run over a curb in an underpass in Harris County, Texas. Upon contact, the officer observed unsteadiness, slurred speech, bloodshot eyes, and a strong odor of an alcoholic beverage. The defendant did not consent to standard field sobriety tests. The DIC was read, and the defendant refused a blood and breath sample. A search warrant was signed and executed.
Can you see any prior DWIs? And have you see it?
I have no license on file, and there's no prior DWIs.
Okay. Mr. Aguilar Barrera, I don't know what your immigration status is, but if you were in this country without permission and you go to jail long enough and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody until this case is over with. and then you will be shipped off to immigration where you will sit for another 6 to 9 months. You do not have a Texas driver license. You are not allowed to drive. Do you understand?
Sí, señor.
Yes, sir.
I don't care what's going on in your life. I don't care if you need groceries. I don't care if there's a burning building and you have to save 50 kittens. You drive, I can have a contempt hearing. I can hold you in contempt, slap you with another 6 months in jail and or a $500 fine every time you drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
Sí, lo entiendo.
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're consuming any kind of alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you. You got out of jail quick because we gave you a PR bond. If you pick up a new case or violate conditions, I will revoke your bond and you will be stuck in there for at least 6, maybe 10, maybe 12 hours. And that's when immigration will put their clutches all over you. This is the only warning you're going to get. Heed this warning.
Yes, sir.
How old are you, sir? What do you do for a living? How much money do you make a month?
Como unos 3,000 a la mes.
All right, we're going to give you time to go hire a lawyer. So I'm going to have you come up here.
I have an
Oh,
attorney.
you do?
Sí, hay abogado.
What is this?
Androgen.
Oh, Androge? Okay, so this is what we'll do. I'm going to have you swear to us you're not going to drive. I'll get you to Victoria to sign a reset. I'll have you meet with Felicia for your bond conditions, and then we'll just have you wait in back for your lawyer to arrive.
Gracias.
Please.
Thank you, señor.
All right, Judge, page 19, crawler, come on up.
You are Mr. Prowler.
No, yes, sir.
Is it, did I say it right?
No.
Prowler or Prol? Is it Prowler? Sir, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, and the complainant and the witness stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant and the complainant, and the complainant and witness pointed to him stating that that was the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Have a lawyer, sir?
Yes, sir.
Is he coming here today? Let's do this. I'm going to hold off on it real quick. I'm going to have you take a seat. Let's wait for your lawyer to get here and then we'll.
That's exactly what he told me. He told me to just explain to you that.
Don't. Let's wait for your lawyer.
He's asked me to, or tell me to explain regarding the case itself. He simply told me to tell you he'll be here as soon as possible.
Okay, just hang tight for me, take a seat for me, and then let me know when he gets here and then we'll continue.
That was the last case.
Okay, any THAs? We're done.
Time to go home.
Let's go home. So I was talking with my other brethren and they said you can on an electric. Hi.
So
So let me see what I can find for you real quick.
I did reach out and I did get an answer back yesterday. And I was told that she can do a portable device, Judge, and that she would not have to do the non-driving affidavit.
Really?
And they sent the contract over, so they will be sending it over to us and let everyone be aware since she does have insurance and since she is eligible to drive.
Oh,
So I don't know where the electric car.
Ms. Gomez said this?
Yes,
Okay, I
yes.
mean, if that's, okay,
And so I know we spoke with her yesterday, so we got to get, of course, everything notarized, signed, and then get her to get the portable. We're hoping to have everything complete by Thursday because we're set to come back here on Thursday with everything taken care of, Judge.
here, let me see.
And I don't know the type.
Will you do me a favor? Give me your cell phone, will you?
Of course.
Right here, just, I'm live streaming, so I don't want you to say it, but if you don't hear, give me your cell phone and I'm gonna text this to you. So in case, because okay, thanks. I'll send this to you now, and I don't know if this is gonna make a difference, but
And you don't know if it has to be the type of education she has or what.
okay, I just sent it to you. Just take a look, and I don't know if this is gonna, whether she wants to do this or whether she would rather do the other one, because on an interlock, you're only blowing when you drive versus when you have a portable device, you're gonna blow in it 3-4 times a day. And it may be at, what if you're in a meeting with a bunch of people and then it goes, okay, blow. If you don't blow, you're in violation, then they're gonna kick you out. So let her know that it's probably gonna be at one of the most intrusive times when it's gonna require her to blow versus just getting it in the car. She only blows when she drives.
So, yeah, and I don't know why I thought it said scheduled, even with the being before, set a scheduled time when you're still part of the low.
I don't know if they put a blow schedule on it in the car. I don't think they do. But I know that when you have a portable, there's always a blow schedule, where here you may not get one. I don't think that they do put blow schedules on it.
Okay, I would-
But it's worth letting her know this is an option worth exploring.
Definitely.
So,
Okay.
Yeah.
Thank you, Judge.
for sure. Hey, tell me. Yeah,
We do have another case on docket, Judge.
Okay.
It would be Jesse Ferreira.
okay,
This was the one, Judge, that we approached on where we didn't submit the mitigation package because we were awaiting the accident report, which is typically required because an accident was involved in order to get possible entrance into the DWI PTI program.
okay.
With that said, I know that was the issue of never having the accident report submitted.
You have it now?
I still don't have it, but I did submit the
Your
mitigation.
Honor, we did request it again yesterday, and we've been following up consistently. There's at
Who are
least
you
5
you asking it from?
from,
The actual officer?
yeah, we're asking it from, yes, from the administrator from the constable precinct. We haven't asked the actual officer himself. We've asked the administrator involved.
How many times have you asked?
The prosecutor that was handling it, I know there was a shift, but she stepped out one morning and actually called and spoke to the officer who said she did have an accident report. And it was just a matter of clicking, I think, some buttons to get it on over. And I know that the state has been diligently following up on that, but it's on HPD or whoever.
So let's do this.
constable's
Subpoena the officer to come to court.
Yes, Judge.
I mean, we'll give it a week. The officer's got to be here in, 7 days with report in hand. Subpoena is taken. If they're not here, I'm gonna have a show cause hearing. The case is 200 days old. We still don't have a damn accident report.
Yes, Judge.
Unacceptable.
And there are some offers, Judge, but of course, we're not willing to move forward on any of
No,
that.
I mean, you got to have all the evidence before you can make an informed decision. And it's 200 days. You still don't have an accident report. You should have gotten that within the next 30 days.
Yes, Judge. We'll subpoena the officer.
So we'll roll to 7/14. I'm sorry, 1/14. And then I'll waive the appearance
Thank you, Judge.
and we'll go from there. Okay? All right.
Thank you.
Thanks. Diana Galindo, come up. Take a seat for me in the jury box. Oh, I was just emailing you, Kim. Your guy Harrison has bond violations. So,
To do a plea today.
okay.
Okay.
Done.
Thanks.
Otherwise, I was gonna put him on for, okay.
Morning, Judge. I have Miss Galindo.
Come up, Ms. Galindo. Come up, ma'am. Is this a first or a second?
This is a first. So Judge, I know that there was she missed on the 19th and the 31st. She's been in a situation where she's only been working part-time. She lost her phone service. I've explained to her that it's her duty to call in and make sure that she doesn't have a drug test on every day. She has been using her mom's phone. The issue is that when her mom goes to work, she doesn't have a phone. I told her that she needs to be able to call and check in every day as the bond conditions require of her. So as she's told me, she is getting a new phone, which should make the situation easier. I've told her she needs to update pretrial services with if her phone number changes, what her message phone is, all those things.
I'm sending you for a drug and alcohol test now, and I hope that you don't test positive. And I'm going to tell you, if this happens again, 3 strikes, you're out. You've missed 2 tests. I don't care what your excuse is. You're supposed to abide by the bond condition of this court. And when you don't, there are serious consequences. You get no more passes. Do you understand? Now I can't trust you. So I'm also now going to give you a device, So now I'm not going to have you call in. I'm going to give you a device. And if I find that you consume, you're going to go to jail. But first things first, I'm going to send up her drug and alcohol test now. We'll have her come back. Assuming she's negative, I'm going to give her a device. If she's positive, we'll have to take another route, but hopefully you're not. All right, take a seat for me.
Judge, I'd like to set this for jury trial, in this case. I'll get a jury trial.
Whatever you want.
Thank you.
Sure, of course.
Judge, you said you'd like to wait till she returns for a device?
Correct. Because if she's positive, then I don't know what we're going to do. But
Judge, we have another.
okay.
Page 23, White, come on up. Yes.
Take a seat for me in the jury box, ma'am. Nope, in the jury box. I don't know what we're going to do. I mean, she's multiple FTAs. It's 240 days. Take a seat for me in the jury box, ma'am. Have you reached out to Jillian? Do you know?
I'll send her an email. I sent her.
Do we have her here anyways today? Do you know? Do we have her here anyways? No? Hi, come on. Yes, ma'am.
I'm here on Raymond Henderson.
You said Peterson?
Henderson.
Henderson, okay.
We're trying to work on a fee against. I just wanted to know if the court would be willing to give him time or credit for the time that he served out of county before he was extradited here.
Sure, of course. Yeah, I mean, it's young though, isn't it?
I think he's old.
No. The case,
Oh,
the case.
Yeah.
It's only,
Sorry.
right?
Yes, it's a newer case. He's got about 17 days of credit built up from out of county. And then he also has some credit here in Harris County.
Okay. What offers have you given?
So we gave a 30-day offer. So we're expecting that with the credit to be time served.
Okay, yeah, I'm down, for sure. Yes, ma'am. Thanks. Hi,
Hi,
good morning.
Happy New Year.
Happy New Year.
I am approaching this morning on, Robert Moore.
War?
Yes, Moore.
Oh, more with an M. Okay. Oh, he's not.
Oh, no, that's somebody else. They both have the same last name. Yeah, I have another case that got moved to Friday. Her last name is Moore. No,
Is this is a new case?
yes, it is. It's a new case.
You mind bringing him up?
Um,
Oh, this is the case. Okay, okay, right. All right, good morning, Mr. Moore. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 31st, 2024, the officer initiated a traffic stop for the defendant's vehicle speeding 61 miles per hour in a 50-mile-per-hour zone at the 6100 block of South Highway 225. The officer made contact with the defendant, driver of the vehicle, and the officer observed an odor of marijuana. The defendant stated someone else possibly smoked marijuana inside the vehicle, and a PC search was conducted. The officer located 3 individual packages with a green leafy substance known to be marijuana based on training experience. The officer located these packages inside a red backpack on the back seat of the vehicle, and the marijuana was weighed, and the weight was 2.87 ounces.
Did you say, you said speeding? Did you?
61 and a 50.
Got it. Okay.
And the issue that I have with the PC, so in regards to the speeding allegation, there were 2 cars in front of my client prior to him being stopped. It was 3 a.m. in Pasadena. He had the nicer car, was pulled over. And also my client explained to officer when he asked him about the smell in the vehicle, he did tell him that he had CBD in the car. He said that I had 3 packs. I just purchased it. They're in my backpack in a bag. They were unopened at the time. The officer did take the bag so that he wasn't, he didn't know how CBD looked or smelled. So he was just gonna find it to be marijuana and would take him in for that, even though my client did prove up the fact that it was CBD in regards.
But if it's CBD and it's unopened, it wouldn't smell, right? Because it's vacuum sealed.
Well, no, he said he smelled something in the car, but the substance that he found in the packages, they were unopened, and those were CBD. That's what he said that he found to be marijuana. But my client let him know that this is CBD, it's in my backpack. When you search, you're gonna find it, it's gonna be in there. But I purchased it earlier today from a smoke shop. And so when the officer did retrieve them out of the backpack and asked about it, he's like, well, I can't tell the difference between, what CBD and marijuana is. I only know marijuana, so I'm gonna have to take you in on that.
What form is this CBD in?
It was like in a little,
Is it?
it was a flower, so.
It is a flower.
Mhm. So I do know that the CBD flower and cannabis flower, they look very similar, so.
Your Honor, if I may, so as the DIMS establishes, so the odor was enough from the search, and finding that leafy substance is enough, because upon further testing, it may or may not, but just for the purpose of probable.
So I think for probable cause purposes, I think it's enough because the odor, right? Now, they're going to test it. If it tests different, then there we may have an issue. But as far as probable cause, and your record speaks for itself, Mr. Moore. Anytime you get pulled over, what's going to happen?
They gonna search me.
You know what I mean? This is what? 1, 2, 3, 4, 5, 6 marijuana case. Anytime you get pulled over with your record, what's going to happen? Every single time. So why give them a reason? Really, we keep coming back and forth and back and forth and no. Can you run his license if he has?
Eligible, Your Honor.
All right, I'm not going to put any conditions. Just be careful. Don't pick up any new cases because I'm going to lose it at that point. You've got a great lawyer. Listen to her. She'll take care of you. If she tells me she can't get a hold of you, I'm going to revoke your bond. Just be good. Don't pick up any new cases. If you're going to drive, make sure you have insurance, car insurance. All right? Okay, guys.
Thank you.
Yes, ma'am. All right. Hi.
Judge, I have an Anisha White on the docket.
Okay, it's getting up there, but
Yes.
not up there.
So I just asked the state to eval the last fine they did. I would like to get a trial date, but.
Of course you can.
Okay, then I'll do that.
Sure. Yeah, just talk to Ramona, whatever you want.
Thank you,
Yeah,
Judge.
of
And I
course.
also have a Coriel Dixon on the docket.
How's Miss Dixon doing?
She's doing well. Judge, she.
Did you finish it yet or what?
No, her last class was on 12/19. Then they took a break and they come back tomorrow. She brought her over the break homework and study guides that she's filled out.
Okay.
So she's been working on it. I asked her tomorrow when she goes back to figure out exactly how long it's going to be before she takes the test, because she took the evaluation test already. Those results aren't back yet because that was right before the break. So we should know in the next couple of days, hopefully.
So let's set it off a week to see, and then we'll go from there. And then, but we're there, we can do just a longer day, huh?
Yep, sounds good. Thank you,
Okay,
Judge.
thanks, bud.
There was a video that's just found in this case.
I know, I saw it. That's why it's. So what, come on up.
Good morning, Judge.
Is he here? Is that him? That's not him, right?
No.
Okay.
My understanding is that he is still home with a sick child. I do have a doctor's note that I showed to the state. I don't know if that's sufficient for the court, but that's.
Okay. Yeah, it's regular.
Thank you, Judge. I do speak.
Yes, ma'am. You ready? Hey. Come up, Mr. Harrison.
Yeah.
Was today his regular setting, or was it a setting that we brought him in because he has bond violations?
This is regular setting.
Okay,
We had accepted the plea offer and we're ready to move forward today, before I got that email.
I have here that you have bond violation, Mr. Harrison, in that you were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions, and I will, to put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life. But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months in treatment if you respond well. Do you understand? But it could be in an inpatient facility for up to 1.5 years of your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated, second offense. They have agreed to reduce it to a first. And I hope that you thank them, because thereby you are now not going to do 5 days in jail, because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash. And one false move, they're going to file a motion to revoke. And if they prove it to me that you violated this probation, get ready. For you to complete it, what are you pleading to is 180 days in jail to be probated for 15 months. As part of the conditions, you will do a repeat offender DWI education class. 2 victim impact panels. You must also do a TRAS. This TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient treatment. I don't know, but that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAD. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test, you must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You tell me now, well, it's not going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Harrison. How do you plead to the offense of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation. And if you did, you were looking at 180 days in jail. Do you understand? Okay. So the other thing that we have to do is the fines and fees for the DPS surcharge. It's a first. So it's a $3,000 fee, but let me ask you this. Is this a 0.15 or above?
To your honor.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be 0.15.
Okay. You should be walking out here with a $6,000 surcharge, but because they reduced it to a first, it's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will sit 1 day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll send you to it. Good luck, son. Thank you, Kate. All right.
Judge, are you issuing a no voting license?
He has the portable device at this time.
Okay.
His license is suspended until February 18th.
Okay. Yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay. So if he decides to, if he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So he can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. You get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. Do you understand? Okay, talk to Kim. She can help you out when that time comes.
Thank you so much.
Thanks, Kim. So the 3,000.
In today's courtroom, one thing became clear. Every choice has consequences. From theft and trespass to DWI warnings and probation risks, these defendants were reminded that the system gives chances, but only so many. Judges don't just pass sentences. They issue warnings meant to save lives, futures, and second chances that may never come again. If you learned something from these real courtroom moments, make sure to like, comment, and subscribe for more daily legal breakdowns.